Hello there, my name is Toby Wilbraham and I'm a solicitor advocate based at Olliers Solicitors in Manchester, advising all aspects of criminal law. I've previously done a video in relation to the procedure for appealing a conviction from the Crown Court to the Court of Appeal, and today I'm going to discuss potential grounds for appealing a conviction from the Crown Court to the Court of Appeal. Please note that this list and information is not exhaustive, and if you have any queries or comments or questions, please feel free to contact myself or anybody in the appeals team at our firm by either telephone or by email. So what do the court, the single judge and the Court of Appeal look at when deciding whether or not there's either leave to appeal a conviction or grounds for appealing a conviction? Well, there's only really one ground, and that is whether or not the conviction could be deemed to be unsafe. Now, there are a number of circumstances which could render a conviction unsafe, a wide variety of factors, and it's looking at these that the Court of Appeal will decide whether or not there is the case or not. I can't go into all of the details, but I'll give a few examples of what could be deemed to render a conviction unsafe. So one situation that can arise which could render a conviction unsafe is where there is a procedural flaw in the case. Something has gone wrong, quite dramatically wrong for the Court of Appeal to intervene, and this could be a number of things. The second part could be bias. If a judge is clearly biased, either against a person, a defendant, or particular witness, the defence case as a whole, and this can clearly be seen by reading through trial transcripts of the case. If a Court of Appeal comes to the conclusion that they feel the judge was in some way biased, then this can render the conviction unsafe. A third factor could be where there are flawed summing up or directions to the jury, where the judge has made a mistake of some kind. It could be an error in law, it could be a misdirection, it could be something that's simply wrong. It could be a misdirection in relation to evidence that he's got the wrong end of the stick for. So if there's something significant, not just minor points, but something really significant that really goes to the heart of the case and undermines the prosecution case, then this can be deemed to render a conviction unsafe. A further factor can be new evidence. Now, this is really new evidence that wasn't available at the original trial. If this new evidence is a witness that could have given evidence at the trial at the time, then that isn't something the court will consider. But if it's a witness that's come forward since the conviction, or forensic evidence that undermines the prosecution case, or something significant, and it really must be significant, then this could deem to undermine the conviction, to show that the original trial, the conviction was unsafe, and that could be a good reason. A lot of things in this area could be new developments in forensic technology, things of that like. And finally, a bit of a catch-all criteria, something else of significance, something that the Court of Appeal consider would really undermine the prosecution case. And it can be anything, but as I say, not minor, trivial, not somebody said something slightly wrong in evidence or said something to somebody later if it was minor after the case. It has to be something that really sheds a doubt on the conviction being safe. So there are a number of different factors. Each of these can be looked at in isolation. There can be one ground that a case could rely on. It could be a number of grounds a case could rely on. And in conclusion, I would suggest that if you're considering appealing a conviction, to get good advice from somebody in relation to doing this, otherwise there is a risk of additional time being added to the sentence.